I'll take the 11.
You may be seated. This Honorable House now resumes its sitting. I wish to welcome all to the sitting of the Honorable House of Representatives for today, Tuesday, February 10, 2026. It is always a great honor and privilege to welcome all of you, and I trust that today's proceedings will progress in its usual productive and cordial manner and in keeping with our standing orders. I would like to extend a special welcome to those joining us in the gallery, those on the various social media platforms, and PBCJ. Today, we are pleased to welcome Her Excellency Marianne Zist. She's the newly appointed French ambassador to Jamaica. Yes. Her Excellency is inviting members to the Paris-Kingston Sound Culture Night to be held tomorrow, Wednesday, January 11th at the French Ambassador's residence on Hillcrest Avenue. The event is being held in partnership with the Jamaica Cultural Development Commission and will feature sound system selectors from both Jamaica and France. Representing Jamaica will be Ricky Trooper, and from France will be Supermana and Twain T. All parliamentarians will receive an invitation from the Parliament. Kindly RSVP if you'll be attending this one-of-a-kind cultural experience. Look forward. Members also present in the House, seated in the gallery, are the President and Vice President of the UTech Law Society, along with 27 law students. Welcome to the houses. I hope you will find today's sitting interesting and you will enjoy your time with us in the House of Parliament. Call of the roll.
Mr. Clark, Mr. Green, Dr. Holness, Dr. Chang, Mrs. Williams, Mr. Bartlett, Ms. Grange, Dr. Tufton, Mr. Mackenzie, Mr. Montague, Mr. Vaz, Mr. Chuck, Mr. Charles Jr., Mr. Morgan, Ambassador Marks, Mr. Samuda, Dr. Wheatley, Mrs. Cuthbert Flynn, Mr. Terry Long, Mr. Witter, Mrs. Dalrymple Filbert, Ms. Morrison, Ms. Lee, Mr. Donovan Williams, Mr. Main, Ms. Crawford, Mr. Delroy Williams, Ms. Hamilton, Mr. Seavright, Mr. Azan, Mr. Brown, Dr. Brown-Burke, Mr. Buchanan, Mr. Bunting, Ms. Burchell, Dr. Campbell, Mr. Cousins, Mr. Crawford, Ms. Daly, Dr. Dawes, Mr. Goulding, Mr. Gordon, Mr. Hales, Mr. Hines, Mr. Hilton, Mr. Jackson, Ms. Jess, Mrs. Malahoo Fort, Mrs. Miller Bennett, Mr. Morris, Mrs. Nita Garvey, Mr. Newell, Mr. Paulwell, Mr. Phillips, Ms. Perkis, Mr. Robertson, Mr. Robinson, Dr. Russell, Ms. Shaw, Mr. Smith, Mr. Dwayne Vaz, and Mr. Warmington. Thank you, Madam Speaker.
Thank you, Clerk. House Leader.
Thank you, Madam Speaker. Let me add my own welcome to the French ambassador. We look forward to fellowshipping with her tomorrow as we celebrate Reggae Month and our sound system culture. Let me also welcome the members from the UTEC Law Society. Very happy to have them here today. We will be dealing with some pieces of legislation, so we can go through the agenda, Madam Speaker. And I'll allow Leader of Opposition, please.
Madam Speaker, I also want to join the House Leader in welcoming the new French ambassador. We met accidentally in Rockfort on her first official occasion in Jamaica. There's a group of French nationals who visit Jamaica every year, and they chose to reside in Rockfort when they come every year. They have adopted Rockfort and as a safe and loving community, and they have established a group called United Jamaica, and they do fundraising in France, and with the support, very ardent support of the French embassy before her and now her. So I really want to specially welcome her to Jamaica and to our parliament, and also to our law students who are here. Thank you.
We could go through the agenda.
Bills brought from the Senate, petitions, papers, reports from committee. We'll take a report from the chair of the Ethics Committee.
Madam Speaker, I beg to lay on the table of the House the following report.
Apologies. Recommittal for announcements.
Madam Speaker, I ask that we recommit announcements.
Yes, Clerk, go ahead. Members, the question is that announcements be recommitted. Those in favor? Those against? The ayes have it.
Laid on the table of the House are the following: annual report of the Betting, Gaming and Lotteries Commission for the financial year 2021-2022 and its related ministry paper numbered 11 of 2026, entitled Annual Report of the Betting, Gaming and Lotteries Commission for the year ended March 31, 2022. Annual Report of the Jamaica Deposit Insurance Corporation for the financial year 2021-2022 and its related ministry paper numbered 12 of 2026, entitled Annual Report of the Jamaica Deposit Insurance Corporation for the year ended March 31, 2022. Annual report of the Jamaica Deposit Insurance Corporation for the financial year 2022-2023 and its related ministry paper numbered 13 of 2026 entitled Annual Report of the Jamaica Deposit Insurance Corporation for the year ended March 31, 2023. Ministry paper numbered 14 of 2026 entitled The International Monetary Fund's 16th General Review of Quotas. Annual Performance Report of the Forestry Department for the financial year 2016-2017 and its related ministry paper numbered 15 of 2026 entitled Annual Report of the Forestry Department for the financial year 2016-2017. Annual Performance Report of the Forestry Department for the financial year 2017-2018 and its related ministry paper numbered 16 of 2026 entitled Annual Report of the Forestry Department for the financial year 2017-2018. Annual Report of the Tourism Enhancement Fund for the financial year 2024-2025. Report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrews South. Report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrew East Central. Report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrew Northwestern. Integrity Commission's investigation report into concerns that the following officers employed to the Administrator General's Department failed to file their statutory declaration with the Commission for the year 2023 contrary to the law. Ms. Chevenise Billings, Senior Case Officer, Ms. Karuma Reed, Senior Case Officer, and Mrs. Keisha Harriet Harvey, Information Systems Executive, and their indicative ruling. Integrity Commission's investigation report into concerns that Mrs. Christy K. Smith Reed, a Director of Public Loans employed to the Accountant General's Department, failed to file her statutory declaration with the Commission for the year 2023 contrary to law and its indicative ruling. And finally, the Auditor General's Department's appropriation accounts, Head 2827, for the Resident Magistrates Court for the year 2012-2013. Thank you, Madam Speaker.
Reports of the Ethics Committee.
Speaker, I want to, again, ask the Leader of Government Business. We haven't seen since, certainly Melissa, but I believe since the last election, any reports coming from the Cabinet. It's a normal practice for, each Cabinet meeting, for a report to be submitted to the Parliament, and as a ministry paper. So I'm asking the House Leader if we have an update on that.
Thank you, Madam Speaker. I did raise the issue with the Cabinet Secretary, who did acknowledge that there was some delay and that they're treated with the backlog and that they would have all the reports in, they had said, by the end of this month. So I know there's a break, but as soon as we return, I expect that those reports will be here.
Chair for the Ethics Committee, Member Malahoo Ford.
Thank you, Madam Speaker. I beg to lay on the table of the House the following reports. 1, report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the member from St. Andrew South. Report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament from St. Andrew Northwestern. And thirdly, the report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrew East Central.
Thank you. Notices of motions given orally.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be it resolved that the report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrews South, report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrew North Western, and report of the Ethics Committee of the House of Representatives on its deliberations on the motion for exemption brought on behalf of the Member of Parliament for St. Andrew East Central, and which were laid on the table of the House on this 10th day of February 2026, be adopted. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Thanks, Member. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House. First obtained. Public business. House Leader. House Leader,
Yeah.
please guide.
Madam Speaker, we'll just take the ethics report first, as that should be fairly quick, and then the Minister of Finance will walk us through the various pieces of legislation, starting with the...
House Leader, turn your mic back on, please.
Hopefully he's walk us through. Then the Minister of Finance will take the various pieces of legislation, starting with the Income Tax Act.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Madam Speaker, I'm going to ask that we hold on the taking of the ethics reports, and we proceed with the Minister of Finance, and then we will revisit the matter of the ethics reports in a minute.
Minister of Finance.
Sorry, Madam Speaker. Madam Speaker, I rise this afternoon to pilot the Asset Tax Specified Bodies Amendment Bill and the Income Tax Amendment Bill. Bills that respond directly to A, the unprecedented national emergency created by Hurricane Melissa, and B, address a long-standing administrative issue relating to the operation of the income tax and asset tax systems, reflecting this government's commitment to fairness, compassion, and sound fiscal governance. Madam Speaker, the Asset Tax Specified Bodies Amendment Bill advance a measured administrative adjustment to the timing of corporate income tax filing and payment, an issue that has been under active policy consideration for several years. On the other hand, the Income Tax Amendment Bill provides a targeted, time-bound response to the disruption caused by Hurricane Melissa by ensuring that employer-provided disaster-related support to employees is treated appropriately under the income tax framework. Madam Speaker, in outlining the provisions before this Honorable House, I will first, Mr. Speaker, in outlining the provisions before this Honorable House, I will first address the measures concerning the filing and payment of corporate income tax, then turn to the amendments governing disaster-related income tax treatment. Mr. Speaker, the administrative amendments I now outline are effected through both the Income Tax Amendment Bill and the Asset Tax Specified Bodies Amendment Bill. By way of background, Mr. Speaker, under the current framework, corporate taxpayers are required to finalize audited financial statements, prepare annual income tax returns, and make final tax payments within a relatively compressed period following the end of the year of assessment. This timeline has long been recognized as a sustained source of compliance pressure for corporate taxpayers and accountants. Mr. Speaker, this timeline has long been recognized as a sustained source of compliance pressure for corporate taxpayers and accountants and auditors, given the sequencing and complexity of year-end financial reporting obligations. The issue of adjusting the annual filing and payment date has been under active consideration since 2021, including a formal proposal raised during the 2021-22 budget debate and a subsequent reference in the Minister's opening presentation for the 2025-2026 budget. The current fiscal circumstances have created an opportunity to advance this reform in a careful, measured manner. Mr. Speaker, the Income Tax Amendment Bill and the Assets Tax Specified Bodies Amendment Bill provide for a limited adjustment to the annual filing and payment date for corporate income tax, moving the final return and the payment date from March 15th to April 15th, beginning with the year of assessment 2025. For administrative consistency, the Assets Tax Specified Bodies Amendment Bill aligns the filing and payment date for assets tax with the revised corporate income tax timeline, recognizing that assets tax assessments are derived from the same underlying financial statements used for income tax purposes. Mr. Speaker, it is important to emphasize that this change is deliberately narrow in scope. It applies only to corporate income tax and assets tax and does not affect pay-as-you-earn individual income tax obligations or the existing quarterly estimated income tax prepayment schedule. The amendment is intended to reduce compliance pressure, improve administrative coherence, and better align revenue realization with fiscal planning, while remaining fully consistent with the government's overall fiscal framework. By way of background and national context, Mr. Speaker, on October 28, 2025, Hurricane Melissa made landfall in Jamaica as a Category 5 hurricane, inflicting devastation on a scale rarely experienced in our nation's history. Several parishes were severely affected, with widespread destruction of homes, businesses, public facilities, and essential infrastructure. Lives were tragically lost, entire communities were displaced, and thousands of Jamaicans were forced into prolonged periods of uncertainty and hardship as a result of the hurricane. Damage assessments indicate multi-billion-dollar economic losses across major productive sectors, including housing, public infrastructure, agriculture, tourism, and other key industries. The physical damage has been estimated at approximately US $8.8 billion, making Hurricane Melissa the costliest natural disaster in Jamaica's history. Beyond physical disruption, Mr. Speaker, the hurricane severely disrupted employment, income flows, and many households' ability to meet basic needs in the immediate aftermath. Mr. Speaker, in this context of profound national disruption and personal hardship, many employers stepped forward to provide emergency financial assistance to their employees. These payments were not made as remuneration for services rendered, but as support for personal recovery, welfare, and basic survival during a period of national distress. Recognizing these extraordinary circumstances, I announced to the House of Representatives on December 9, 2025, that the government would move to establish a framework to allow the non-taxable treatment of disaster relief support provided by employers to their employees following Hurricane Melissa. That announcement, Mr. Speaker, reflected the government's clear view that the automatic application of the tax laws should not diminish humanitarian assistance provided in response to a declared disaster. Mr. Speaker, the Income Tax Adjustment Bill, now before this Honorable House, gives legislative effect to that commitment. It converts a necessary policy response into a clear statutory framework, providing certainty to employees, employers, and the tax administration alike, while ensuring that compassion and fiscal responsibility are properly aligned in law. Mr. Speaker, this Honorable House is reminded under Section 2.1 of the Income Tax Act that emoluments are defined broadly to include salaries, wages, fees, and any other benefits arising from employment, all of which are ordinarily subject to tax. Additionally, outside of the Minister's discretionary remission powers under Section 86, which applies only where there is a considered just and equitable on a case-by-case basis, there's no standing statutory provision that allows disaster relief payments to be treated consistently as non-taxable following a declared disaster. The reliance on discretion alone, Mr. Speaker, is neither efficient nor equitable in the context of a large-scale national emergency. It creates uncertainty for employers seeking to assist their workers, inconsistency in tax treatment across similarly situated employees, and inequity for those who may receive relief only to see it partially eroded through taxation. Mr. Speaker, the bill provides that disaster-related honoraria paid by employers to employees during the period from November 1st, 2025 to March 31st, 2026 will not be treated as taxable income in the hands of employees. At the same time, the bill allows such payments to be treated as deductible expenses for employers, provided they are genuinely borne by the employer and supported by appropriate documentation. The bill, therefore, corrects an outcome that would otherwise undermine the very purpose of the relief being provided. Mr. Speaker, it is important to emphasize that this relief is carefully bounded and does not represent an open-ended exemption. The measure is deliberately limited to a defined post-disaster period and is designed to operate only in the specific context of Hurricane Melissa recovery. Further, the framework includes a prescribed cap to be determined by the minister, intended to strike an appropriate balance between providing meaningful support to affected workers and maintaining the principled structure of the income tax system. This approach, Mr. Speaker, minimizes revenue risk and ensures that the exemption remains proportionate in nature, duration, and fiscal impact. In addition, the Tax Administration Jamaica is empowered through prescribed record-keeping and reporting requirements to verify compliance with the relief, thereby safeguarding against abuse and ensuring transparency and accountability in its application. Mr. Speaker, the ministry is not done yet. Mr. Speaker, while this bill addresses the immediate circumstances arising from Hurricane Melissa, it is not intended to be the final word on how disaster-related employee support is treated in our tax system. Recent events have made it clear that Jamaica would benefit from a more enduring framework for managing disaster-related payments in future emergencies. It is with this thought, Madam Speaker, that the government has further amended the bill to include the permanent mechanism to allow for clearly defined disaster relief support to be treated consistently under the income tax regime, subject always to appropriate oversight. Mr. Speaker, these bills honor the commitment announced to this House. They support workers during recovery, provide certainty to employers, improve administrative efficiency, and preserve the integrity of the tax system. I therefore commend the Income Tax Amendment Bill and the Assets Tax Specified Bodies Amendment Bill to the honorable members of this House and invite your support. Mr. Speaker, may God bless this honorable House and may God bless Jamaica. Thank you, Mr. Speaker.
Member from St. Andrew Southeastern.
Thank you, Mr. Speaker.
Turn your mic on, please.
The amendments here aim to do three things. The first one related to the relief from employers to employees. When the minister brought it a couple of weeks ago, I indicated that we had no objection to what you were proposing. I questioned whether 200,000 was sufficient, but you said based on your own research. The question I would have, does this also allow the employer not to pay NIS, NHT, and other deductions that they would normally pay to an employee? Is the relief only for income tax, or is it the relief for all the other applicable taxes that an employer is obliged to pay to an employee? The second thing, to move the date, the filing date from March to April, it is not something that we would have an objection to. I believe it puts the government in a better position to understand the amount of taxes it would collect by the end of the fiscal year, March 30th. And as the minister said, it's something that has been recommended by both tax professionals, and the fiscal commissioner actually in his last report recommended it. Minister, there is one question I have which is related to section 4B, item 5. And the section reads, every person delivering a return of income shall include with the return a statement in the prescribed form or such form as may be agreed by the Commissioner General of the tax chargeable on that income under this Act, indicating how much, if any, of that tax remains unpaid, and the tax so indicated as unpaid shall be treated as if it had been the subject of a notice of assessment served on that person. I just want clarity here. Are you saying that when you file, and if you have not paid everything, and you so indicate, you will automatically be the subject of an assessment by the tax authorities? I'm just seeking clarification on that section. But the other two, as I said, we don't have objections, but I would like you to indicate whether the other taxes are, the employer will be relieved of the other taxes.
Member from West Central, St. James.
Thank you, Mr. Speaker. Mr. Speaker, as I said earlier, this bill entitled an act to amend the Income Tax Act is seeking to do a number of things. My contribution will be limited to the provision for relief in respect of Hurricane Melissa. Mr. Speaker, the minister is being empowered to exempt from income tax certain payments. It is unusual to set out in the primary legislation the details that are set out here. And if you look on the scheme of the provision, you see already where the minister is empowered by order, subject to affirmative resolution, to exempt certain payments. what is in the subsection could not be construed as including the sums that are specified. And I would like to propose for the Minister's consideration an amendment to the provision to make the provision general and to enable any subsequent relief that is to be granted after decision is taken to prevent the need to amend the legislation again. And I believe if the provision were to be worded along the line of with effect from November 1, 2025, such sum as may be prescribed by the Minister by order subject to affirmative resolution, which is paid by an employer to an employee for personal recovery and welfare due to loss or damage suffered from the effects of an occurrence referred to in Section 20, subsection 2, paragraph C of the Constitution, or a disaster which is the subject of an order under Section 26 of the Disaster Risk Management Act. It would allow for the goal to be achieved without having to come back to amend the principal legislation. And I think it's the same thing, it's just a matter of how it is provided for.
Member from St. Andrews Southern.
Thank you, Mr. Speaker. A couple of points on this bill to amend the Income Tax Act. First of all, I join in the query raised by my colleague, the member for Southeast St. Andrew, as to whether this exemption being granted to employees from paying income tax on up to $200,000, whether any similar exemption will apply to other statutory contributions and obligations that apply to payroll, such as NIS contributions, NHT contributions, HART, which is an employee cost, and so on. This would only apply to income tax. So if it is not done with the others in mind, the employee would still potentially be liable to pay contributions under $200,000 under those other laws that govern those matters. So I think it's an important point for her to clarify for the House. Secondly, I was puzzled when I heard the minister say that there's a mechanism for making this a permanent facility because the amendment to Section 5 is very specific to payments of not exceeding in the aggregate $200,000 paid by an employer to an employee between November 1, 2025 and March 31, 2026 for personal recovery and welfare due to loss or damage suffered from the effects of Hurricane Melissa. So it specifies the time frame, it specifies the amount, and it specifies the specific disaster. So this is obviously not going to impact future events where the government may wish to provide similar relief. So I would endorse the approach, though not necessarily the specific wording proposed, because it's hard to follow it orally, but the approach being suggested that would provide a mechanism in Section 51C4C to allow the minister in the future, by order, subject to bring it to Parliament for affirmative resolution, to implement whatever may be the appropriate level of relief in those circumstances in the future, without having to come to amend the Income Tax Act again to do so. Thirdly, on the matter of the date for filing of corporate income tax returns, I agree with this amendment to move it to a date in April, the 15th of April. Indeed, I had called for that in my budget presentation, I think 2 or 3 years ago, that be done. So I'm happy to see it being done. I would just like to read an excerpt from the statement on fiscal affairs from the Independent Fiscal Commissioner, which was published in September 2025 in respect of the first quarter of this fiscal year. And he said, and I quote, "Of note, the fiscal balance and primary balance, i.e. 0.2% of GDP and 5.4% of GDP respectively, were broadly in line with their corresponding programmed values under the third supplementary estimates and the initial budget. Notwithstanding, tax revenue of $882.8 billion was lower than originally budgeted by $16.5 billion, or 1.8%, and $14.2 billion, or 1.6% less than estimated under the third supplementary estimates. The bulk of the shortfall occurred in March, the last month of the fiscal year, when income tax returns are due. This is talking about March 2025. It is against this backdrop that the Independent Fiscal Commissioner reiterates its call for the government of Jamaica to shift the due date for tax returns from March to a month in the first quarter of the fiscal year to better manage the risks associated with revenue shortfalls. And that, I think, summarizes another reason why it's important to make this amendment, because by having tax returns filed in the fiscal year itself, in the last year, it's very difficult to budget for the coming year because you don't know what your actual revenue for the current year will end up being. And that has been identified by the Fiscal Commissioner as a fiscal risk, which should be remedied. So I am happy to see what I had proposed a few years ago, what the Independent Fiscal Commissioner had proposed, and I think the minister's predecessor had also seen the logic of it being enacted here today. The other two issues I would like to hear from the minister on. Thank you, Mr. Speaker.
Minister.
Sure. Thank you. Thank you, Mr. Speaker. With regards to section 67B, the member asked about whether or not those who file, if they have tax that remains unpaid, would they be assessed? And no, it is not about an assessment. It's about the making sure that, hold on the date. The section is really creating a deemed collection date, not a deemed assessment. That is what that is doing there. And with regards to the question, will statutories be exempt? Member, yes, they will be exempt. All the others for that. The law says it's exempt. So when you do your filings, and it is also, well, all the other taxes would be relieved because these pieces of legislation rely on the definition of emolument in the Income Tax Act. Therefore, to the extent that it is not charged to income tax, it will not attract the other statutories, right? And I answered your prior question about the assessment versus the collection date. Okay, I think that's it.
Go ahead, let me hear the point of order.
If you ask your questions on mic for the benefit of the record. Thank you. Angela, why are you so miserable today?
You want to move? Sorry. So, Mr. Speaker, clearly, as the minister is moving to close the debate, some suggestions have been made. So we're going to just suspend the debate on the Income Tax Act so that the minister can have that consultation. But as the team is here and the minister does have additional matters, we're going to move into the next matter, suspend this so that you can consult on the point that has been raised.
And that for the income tax?
For the income tax. So we suspend the debate and the minister will move into the asset tax?
Asset tax.
Amendments to the asset tax.
Minister.
Mr. Speaker, in my opening remarks, I did speak to the income tax and the asset tax as well, and so I would, seek any
The floor is open
questions
for members to contribute. Minister, are you asking for the second reading of the asset tax?
So, Mr. Speaker, the minister did open on both asset and income tax in her opening. I know questions were raised in relation to the income tax. Now, if there are questions in relation to the asset tax, or, yes, understood. Yeah. So we will allow it. We'll allow it.
So as it is, we'll allow the situation to flow for the asset tax. Member from St. Andrew, Southeastern.
Thank you, Mr. Speaker. When the asset tax, the amendment to impose 0.25% taxes on the assets of financial institutions was done in 2013, the country was at a particular state. We were seeking to reestablish our credibility with the international financial markets. We had to run high primary surpluses to ensure that we could meet the debt obligations and to bring our debt to GDP ratio down from high levels, 140. And that formed the basis, the heavy lifting formed the basis of where we are to date. Subsequent to that, when that was introduced, it was always deemed a temporary measure, given the context of the times that we were in. And a commitment was provided by both predecessors, Aldershaw and Nigel Clark, that the asset tax would be removed. because there was a recognition that of the negative impact that that tax was having on the financial sector. We are gone 10 years now, Mr. Speaker, since those commitments were made to remove it. And we are yet to get any specific action from the government on this specific issue. So, in relation to what is being proposed, the date change, we don't have an objection to that. However, I got a little excited last week when you tabled it because I thought the amendment was related to the asset tax itself. And so my question to the minister is, when will the government act to provide relief on the asset tax itself, which has been a commitment made by 2 ministers on that side over the last 10 years, and which the financial sector itself has been calling for a protracted period of time?
Mr. Speaker, just to understand the process we're in, my understanding is that 2 bills were tabled that we're dealing with. One is the Income Tax Amendment Act, and the other is the Asset Tax Specified Bodies Amendment Act, both of 2026. The minister in her opening spoke to both bills, but they are not companion bills. There's no reference in either of them to the other bill, although they do have a provision which changes the relevant date for filing to become the same date, April 15th of the year, but they are not companion bills. So what we are now doing is debating the second of the 2 bills, the one dealing with the Asset Tax Act, because we have suspended the debate on the first bill, which was dealing with the Income Tax Act, for the minister and her team to consider some matters that were raised in that debate. Mr. Speaker, like the member from South East St. Andrew, I think the minister ought to speak to the status of the asset tax, because when it was imposed in extraordinary times, and there was an express commitment given by the government of the day that it would not be kept there beyond a short period of time. That commitment was not ultimately kept to, and subsequent ministers have repeated those commitments, and yet we still have this tax on the books. It is to be understood that this is effectively a tax on the capital of financial institutions and adds significantly to their cost of doing business, and therefore has an impact on lending rates in the society. So it affects consumers, it affects businesses through the cost of money in the Jamaican economy. And at a time when we are trying to transition from being a low-growth, low-tech, low-wage economy to having strong, robust economic growth, taxes and tax policy are important because they can be counter-cyclical or have counteracting effects to the underlying policy that Jamaica is trying to pursue. And I would argue that this particular tax is an example of that, because by taxing the capital effectively of financial institutions that are licensed, it increases their costs, which result in higher spreads, higher interest rates, and higher costs of money in the economy generally, which dampens growth, dampens borrowing, dampens economic activity. So I'm going to ask the minister to indicate what is the government's policy in relation to this tax, and when does she envisage it being either completely removed or phased out? I know that we're in a context of depressed revenues from Melissa, so I would not expect her to announce that it is going to disappear now. But the projections are for the economy to recover over a 2 to 4 year period. What is the government's policy in relation to the ongoing existence of this tax, which is the subject of much concern expressed by those who understand what impact it has on the economy? Thank you. Mr. Speaker.
Member from Eastern Portland.
Thank you, Mr. Speaker. Minister, I just turning your attention to the actual amendment at 2. My contribution is just about the reading of the amendment. In particular, the second line, it says substituting it as therefore. Just considering whether or not that is the spelling that you want for it, as well as where it has the first day of September, if it was by a term of art, to have it have it exactly like that, of September, or should there be a space there? This is in relation to the amendment, so it's just a matter for you. We're talking about the amendment, the asset tax. So it's just a spacing on the wording. So you feel free to respond. No. It's, as I said, it's legislation and it's just a matter for you. It's not. I'm not being pedantic. Thank you.
Mr. Speaker, I'm glad that the opposition admitted that they were the ones that imposed the asset tax in 2013. Yes, there's a commitment on this side to roll back the asset tax. However, we've just come out of a Category 5 hurricane that has devastated the country, but our commitment remains that as soon as budgets allow, we will begin the rolling back of that. With regards to the member from Portland Eastern, the technical people, the drafters, will tidy up this thing as we go along.
Minister, you want to ask for this reading?
Mr. Speaker, I ask that the bill be read a second time.
The question is that the bill be read a second time. Those in favor? Those against? Ayes have it. Clerk.
A bill entitled An Act to Amend the Assets Tax Specified Bodies Act, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Minister, there are two clauses. How would you like to proceed with them?
There are no amendments, and if it's fine with the House, you could just put en bloc.
We now put clause 1 and clause 2. Those in favor?
Aye.
Those against? The ayes have it. I put the title enacting clause. Those in favor? Those against? The ayes have it. The question is that I do report the bill as having passed committee stage without any amendments. Those in favor? Those against? The ayes have it.
I'll repeat, we're back in the House. I do report the bill as having passed committee stage without amendments. Minister?
Madam Speaker, I now ask that the bill be read a third time.
The question is that the bill be read a third time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Amend the Assets Tax Specified Bodies Act read a third time and passed.
House Leader?
Casino. Madam Speaker, we will now go to the casino gaming regulations.
Minister, you may proceed.
Thank you, Madam Speaker. Madam Speaker, I stand here today to commence the debate on the Casino Gaming General Regulations 2025. Madam Speaker, these regulations are made pursuant to the powers granted to the Casino Gaming Commission under Section 72 of the Casino Gaming Act, which was passed in the year 2010, hereinafter referred to as the Act, and represents a seminal tool towards supporting the nascent casino gaming industry in Jamaica. Thus, Madam Speaker, the Casino Gaming Commission has made these regulations, which have been approved by me as Minister. Madam Speaker, you may know that a regulatory reform of the gaming sector is underway as part of public sector transformation, and hence the government has embarked on the merger of Betting, Gaming and Lotteries Commission, the Jamaica Racing Commission, and the Casino Gaming Commission to achieve economies of scale. Notwithstanding this, Madam Speaker, and the progress we have made so far with the merger, which will continue to be pursued, the government must take advantage of the opportunities that present themselves to invite foreign direct investment into our country in the form of Integrated Resort Developments, or IRD. Madam Speaker, may I remind this honorable House that IRDs, which are a development consisting of a mix of various tourism amenities such as hotel rooms, villas, sporting and entertainment facilities, shopping centers, and casinos, is one of the many ways this government intends to broaden Jamaica's tourism offerings and create greater economic development. Madam Speaker, you may recall that in 2025, the Casino Gaming Commission received its first casino gaming license application, making Jamaica's progression into a new tier of tourism and investment opportunities. It is in this context, Madam Speaker, that it was determined that there was need for a dedicated regulatory framework to safeguard the integrity of operations, protect Jamaica's reputation, and meet international standards for financial crime prevention and responsible gaming. These are the key objectives that are intended to be met by these general regulations, which will, along with the Act and the existing regulations made pursuant to the Act, complete the regulatory framework to establish Jamaica as a casino gaming destination. Generally, Madam Speaker, these regulations establish the foundational rules that govern administrative processes of the Commission, obligation of licensees, record-keeping and reporting requirements, regulatory fees and procedures, powers of inspection, investigation and enforcement, and general standards necessary for orderly and transparent operation of the industry. Madam Speaker, I will now proceed to examine the regulatory provisions. The Casino Gaming General Regulations 2025. Regulation 1 states the short title, Madam Speaker, and the name of the regulations, the Casino Gaming General Regulations 2025. Regulation 2, Interpretation, sets out certain critical definitions relevant to the operational conduct of casinos. Regulation 3, 4, and 5 make provisions for the organization structure of casinos. This is important, Madam Speaker, as casino gaming, unlike other forms of gaming, is a high-value, high-risk sector. Regulations 6 and 7 provide for staffing and realignment of functions in a casino. Madam Speaker, to maintain proper conduct and supervision and control, casinos are required to maintain staffing in keeping with internal control standards approved by the Casino Gaming Commission or as per the directions of the Commission. Regulations 8, 9, 10, 11, and 12 address internal control standards and accounting procedures. These provisions, in summary, require the implementation and compliance with internal control standards approved by the Commission, as casino operations are highly regulatory operations. Regulations 13, 14, and 15 address the need for the establishment of a compliance committee, which will, among other things, prepare a compliance plan to govern the casino operations. These provisions outline the composition of the compliance committee and its functions. Regulation 16 addresses the power of inspectors and authorized persons to determine compliance with the minimum and approved internal control standards of the casino. Regulations 17 through 27 make provisions of the records and accounts that are to be kept by the casino operator, who is to maintain all financial records and reports in accordance with International Financial Reporting Standards, IFRS. Regulations 18 through 32 address the provision of credit to patrons, credit policy, credit agreement, and records of credit facility. These provisions are in keeping with international standards in circumstances where the casino extends credit to patrons. Regulations 33 to 44 address certain important requirements on casino surveillance and security, which are important features to ensure security, fraud prevention, and regulatory compliance. Regulations 45 to 52 address patron disputes and complaints, where the Commission can elect to intervene in a patron dispute or handle a complaint after carrying out investigations. Regulations 53 to 59 address gaming equipment. The standards they need to meet, which are standards issued by the Gaming Laboratories International, LLC, which provides the gaming industry with testing services and the application for approval of gaming equipment, amongst others. Regulations 60 to 65 address gaming machines, the application and modification and related issues. Regulations 66 to 71 delve into the conduct of gaming, Madam Speaker, and address issues such as the prohibition against intoxicated patrons, issuance and redemption, use and payment and permissible use of chips, amongst other things. Regulations 72 to 84 address table games, dealing and shuffling, the making of wagers, closing of gaming tables and gaming machines, the duties of persons in specified offices, amongst other things. Regulations 85 to 88 address progressive casino games, such as progressive jackpots. Regulations 89 to 90 address commission facilities. Madam Speaker, a casino operator in Jamaica is required to provide and maintain appropriate office facilities and equipment for the commission officers, employees, and agents. This is in keeping with best practices. Regulation 91 provide for general offenses and penalties. The first schedule contains the detailed table game equipment technical standards and requirements, which are quite extensive, Madam Speaker. The second schedule contains relevant offenses and penalties. The third schedule contains gaming machine tokens, technical standards, and requirements. Madam Speaker, with these regulations, the government intends to continue to fulfill its commitment to vary our tourism product. With these regulations, the framework needed to operationalize casino gaming in Jamaica will be fully in place and will support the processing of license applications and ensure that the first casino expected within the Princess Resort IRD opens under clear, modern, and enforceable regulatory conditions. Madam Speaker, I now invite members of this Honourable House to support the affirmation of these regulations. Thank you, Madam Speaker.
The member from St. Andrew Southeast.
Thank you, Madam Speaker. I just have a couple of questions for the Minister in relation to the regulations. Could you state how many casino gaming licenses have been issued by the government so far? In relation to the Large-Scale Projects and Pioneer Industries Act, it called for the establishment of a committee that would review applications from companies that were interested in establishing integrated resorts. Could you confirm whether that committee is in place? And if so, can you state the status of the application from the Tavistock Group, which is a partner with the government of Jamaica in the Harmony Cove development? Could you also indicate whether the government of Jamaica, as a partner in that development, has fulfilled all its own requirements for the project to proceed to where it is today? And finally, could you indicate the model, whether it is from a particular jurisdiction that was used as the basis for the development of the regulations that you are now seeking to pass today.
Minister, hold a moment, please. The member from St. Catherine Northwest.
Yes, Madam Speaker. Can I borrow it? Delano, lend me. Madam Speaker, this is a particular issue that is close to my heart. Previously in the lower house, I had indicated some concerns in the upper house. I had indicated some concerns for which I won't rehash today because we are not discussing whether or not we will have casino gambling, but instead we are far along that trajectory. We have already granted license, and so the debate has to shift to governance and what should governance include. So we're not having the question of whether or not we should have casinos, but indeed, how do we ensure that the high risk is mitigated and that the great benefits are maximized. In any area of government, Madam Speaker, one must ensure that there's regulatory equilibrium. In this case, it must be that it is not only strong technically, but that it represents a people-centered and a Jamaica-centered approach. Indeed, let us not misunderstand casino gaming to be the same as gaming lounges. There's a much higher risk to casino gaming than gaming lounges. And to that extent, there must be adequate attention paid, and not just an extension of oversight from that which existed before. What we are seeking to do now cannot be an extension only of what applied to gaming lounges, but that there must be a greater logic around casinos. To be fair, Madam Speaker, there are some strengths in this bill, one of which is the internal control systems and structures, segregation of duties, though there might be a need for rewording of some of those spaces where it's stated to prevent more so than to mitigate. It would be impossible for regulations to prevent fraud, for example, but the regulations are important to mitigate against it, and some of those words need to be reviewed. Segregation of duties is important. Surveillance standards have been strong. Record keeping in these regulations seem to be strong. Equipment certification controls to ensure that there is no bamboozling and bandooling of persons seeking to gamble. Integrity foundation is present. However, Madam Speaker, that alone is not full governance. System protection is indeed not people protection. Let's look at some of the core gaps that I found in that consideration. First of all, it's system protective, it's investor assuring, it's technically structured, but again, as I repeat, it's not people-centered, it's not people protecting, and it's not Jamaica-centered. While it protects the system, it exposes patrons, workers, and local suppliers without much mandate within these regulations. Let us be clear that these mandates neither existed in the license that we granted, and therefore this may be our last bat at the wicket to ensure that there is some protection in these cases. One of the gaps, of course, is that the patron's protection is lacking. If you look at Part 3 Regulations 8 to 12, it mentions problem gambling, but just a mention. It actually does not operationalize, the protection of problem gambling. Now, we must note that one of the main differences between gaming lounges and casinos is no limit. A person can bet his full stock at any given time. In the initial conversations, I was against the participations of Jamaicans. However, we are where we are. And so therefore, how do we protect Jamaicans? And there are countries such as the Bahamas that limit resident participation in casino gaming. But we had made decisions counter to that, and so we are where we are. No national exclusion registry is in place. No third-party reporting channel. No mandatory intervention standards. So, for example, a person who is having a gambling problem, there's in the regulation that he can self-report. But having self-reported, there is no national registry. So it's almost as if it is curtailed to that casino. And that him can go to Caymanas tomorrow and then continue his gambling negatives. Indeed, it is within short order we expect to have more than one casinos. And so therefore a registry becomes even more important. I believe the bill indicated that we can have up to 3 casinos. But there are other forms of gambling. And then if this person is having the negatives of problem gambling, the extension of that must be protected moving forward. No, there's no, Madam Speaker. Madam Speaker, Madam Speaker, can I have some protection, Madam Speaker? There's no third-party reporting. And therefore, the regulations insist that the person with a gambling problem must be a reporter of himself. And there is no way that his or his wife or her husband or children can then carry out a third-party reporting system that mandates intervention because this person hasn't acknowledged that they are having a problem. In this case as well, there were no mandatory intervention standards. We recommend that a national self-exclusion registry or a national exclusion registry should be in place. That third-party reporting, especially from family and community members, churches, etc., co-workers, as well as boss and employees and employers should be able to make such recommendations. We recommend that social workers should be able to participate, that mandatory staff intervention training should be there to identify problem gambling, and that we should have recorded intervention protocols and behavior triggers moving forward. Madam Speaker, this is not new. As in United Kingdom, for example, there are customer interaction rules and third-party reporting. In Canada, provincial casinos, there are centralized exclusion registries, and in Australia, there's a mandatory intervention trigger that we can look at those regulations moving forward. There's also a gap in debt gambling. Casino credit is actually allowed, and debt gambling is the strongest harm and one of the greatest negatives that we can have. Documentation is there, but there's no protection. For example, when you allow for credit gambling, there's what we call loss chasing. A person is losing, they continue to chase a regain of that negative. In fact, he always believes that the next chance is going to be the victory. And this is more negative for the poor who went there with the need to earn and not just the value, the entertainment value of gambling. So a lot of persons with low income attend the casino with the need to get his rent, with the need to get his daughter's school fee, and therefore not get to that, the need to find the car payment, and in the need to find the car payment, lose the rent. And then he's in the last chasing to get back the rent because now he's in the thing on credit. Now, Madam Speaker, this leads to household collapse. This leads to multiple loan cycles, workplace misconduct, thievery. This leads to mental health risk, and indeed have been proven to lead into suicide. We recommend, therefore, that we prohibit casino credit for Jamaica residents. Now, the large persons who are gambling to be competitive for these big gamblers who fly in, credit in the casino is allowed. but we believe for Jamaica residents, there should be a limit on, in fact, a prohibition of casino credit. We also feel that there should be a ban on credit card gambling transactions. Now, that was actually stated in the regulations that you shouldn't be able to directly buy chips. But later in the regulations, it indicated that you could register your credit card. And so therefore, while you couldn't directly buy chips with your credit card, a loophole existed where you could register your card and later do whatever. Now, the fact that it's an integrated resort development, then you could be staying in a room because it's an integrated resort development. Then you could have been at the restaurant, but it has no limit, having registered your card, on what you can use that for. And we believe that there should be a limit on that. Therefore, you allow only cleared available funds for residents. Tourists can do as they feel. And this exists in designations like the United Kingdom. Credit card gambling is banned in the United Kingdom. So therefore, these exist. Credit card gambling is also prohibited in Australia. Canada, resident casinos, credit is restricted. We also believe that there should be mandatory spend limits, and that should be daily, weekly, and monthly limits, so that for residents, Jamaican residents, in the main, the conversation here is for Jamaican residents, because that is our ultimate duty to protect these individuals. That there should be mandatory spend limits. Now, therefore, within the thing, we saw no enforcement of spend ceilings, and the limits seem to be voluntary with no real structure. Mandatory maxes should be there for daily, weekly, and monthly, and we feel that there should be a tiered verification system for persons who we perceive to be going above their threshold. Australia is promoting loss limits, and even in Europe, multiple jurisdictions have mandatory limit systems emerging. Additionally, I think that there were gaps as it relates to local employment. There are within the regulations the requirement for adequate competence. However, there is nothing there for operator skill development, and that could lead just to the importation of skill as versus to the development of our Jamaican citizenry. And so no skill transfer program was in the regulation, no period of replacement was in the regulation. And so we may find that you just have people from America, from existing casino spaces, coming from the Philippines, and therefore we are recommending that both local and CSME minimums for employment threshold, not just line staff, but management could be considered as a part of our casino experience. Also, we should have targets for quotas of employment, operator-funded training academies. Now, this is very important because to this point, we have not had a conversation about the casino-specific skills. And we have casinos that are about to be open. But who exactly? And also, it becomes parasitic to the current hospitality practitioners who then lose staff to the casinos, who then have to be parasitic because they're not preemptive. Member from my adjoining constituency, they're not preemptive in ensuring that the staff training is. And I need back mine from you, we swap, right? So therefore, we will want that limit. Additionally, we could work with HEART to be doing some training now in the casino skills and the certification pathways. We believe that there should be local understudies for any expat, and those mandates should be in place, and we should have skill transfer milestones. These exist, for example, in Singapore. Integrated resort training academies are required in Singapore. They must have training academies. Workforce conditions are tied to license in Australia, and local workforce development obligations exist in Canada. We saw none of those in our regulations. And so, therefore, the Jamaican license didn't guarantee Jamaican careers or Jamaica employment. Another problem we saw was that resorts can become spending enclaves, and it was indicated that they will have restaurants, they will have shopping, they will have casino, they will have room, They will have attractions and amenities. It therefore means a person don't have to leave that space. And that is a danger towards the tourism industry as is, because it actually sacrifices time and money, which is necessary for attraction consumption. So a lot of our tour operators, etc., may be concerned that this is going to be a competitive activity more so than a complementary activity. And there was nothing in the regulations to encourage the complement capacity of it more so than the competitive capacity of it, such as, for example, advertisement spaces, such as, for example, allowing for booking tables within the space so that it doesn't become a parasite on the general economy. And this, from an economic standpoint, Madam Minister, is very risky, because these persons will send back the profits to the international mother spaces and mother countries, and therefore, especially with local gambling, becomes more of a consumer of income more so than a producer of income, robbing the shops, robbing the bars, robbing the round robins right, and sell it back overseas. Therefore, we were also concerned that there was no supplier participation requirement, no procurement reporting, no structural local linkage rules. And it seems as if we don't seek to change the mistakes that we have made in the past, because we have made these mistakes before, right? And we have not, in now getting another bite at the cherry, sought to make some of these realities. For example, these large things, I've seen nothing to suggest that they need housing as a part of their thing, which we have seen squatting evolve based on tourism construction before, with the gravitation to the space so as to participate in construction and in seeking opportunities. We saw nothing in those regulations. And so, therefore, we thought that the local economy linkage plan should be created, that they should have to create a mandatory local economic linkage plan, that local procurement targets should be set, annual local spend should be reported, SME supplier development programs should be in place, open vendor registry for Jamaican firms, and Jamaican cuisine, culture, and entertainment should be included. I've been to some hotels, not many. I'm not as wealthy as some of the others over that side, who have been to all the hotels. But I've been to hotels with more. No, me and you not the script. Me and you not the same thing. We not the written speeches. But what happens there? I've been to hotels, multiple restaurants. Yes, me and you. All right. Multiple restaurants, and only a Jamaica night. Multiple restaurants, and therefore, if Jamaica cuisine is not being consumed, then Jamaica agriculture is less likely to be consumed, because the cuisine defines the input. So when you are going to be having pancake for breakfast, then how breadfruit are going to sell? When goat is stuck only to Friday night, then how is it our farmers are going to, because leg of lamb is the thing. These large hotels should be mandated to have at least one local restaurant that then now becomes an exposure to consumption and the consumer of our local produce. Again, this is not abnormal. Local linkage obligation is set in Singapore. Community supplier framework exists in Canada. Regional procurement commitments are required in Australia, and we have not implemented those things moving forward. So, in essence, at this point, I'm not having a conversation that I'm anti-casino. That is long gone. That conversation have moved. But we must be pro-governance. We must be pro-protection of our citizens, and we must be pro-encouragement that it does not become an enclave, but instead become an anchor. And so, we are recommending, just for conclusion, that we have an exclusion registry, third-party reporting, resident credit ban, credit card ban for gambling, mandatory spend limits for Jamaicans, local employment minimums, skill transfer mandates, and local supplier linkages, including guaranteed entertainment consumption. I don't see the minister today, but in some of our hotels now, we have persons from overseas providing entertainment in some of our hotels. And so therefore we want to ensure a country awash with entertainment talent, that is reserved for those realities. So, Madam Speaker, I'm not seeking to promote fear, but indeed to promote structure. National benefits must exceed national harm. And to that extent, Madam Speaker, I move that we reconsider the inclusion of some of these recommendations in the regulations as they exist. Thank you, Madam Speaker.
Next, the member from St. Andrew North Central.
Thank you. Thank you, Madam Speaker. I want to stand in full support of the Minister of Finance promulgation of the Casino Gaming General Regulations 2025, as frankly, they are long overdue. They finally, fulsomely operationalized the Casino Gaming Act, which was passed in 2010, and it is putting in place detailed rules that are needed for Jamaica's nascent casino industry that will be within the integrated resort development model. So the passage really is a fillip to Jamaica's economic fortunes, and it's adding a new high-value dimension to our tourism and commerce offerings. And it's complementing hotels, entertainment, conferences, retail, travel, everything, while strengthening Jamaica's competitiveness at the level of the Caribbean and also globally. I don't know which hotels the member visits, but I've seen ackee and saltfish, banana, yam, breadfruit at all the hotels, including the major all-inclusive. So if you want, I could probably show you some of the hotels. I don't know where you're going, but I see ackee everywhere. Ackee Festoon dog. So I am not understanding your position on that issue. And beyond that, what is really amazing is that the regulations that have been promulgated, they follow global best practice. They are full, high standard casino ecosystem regulations that are standard in some of the best jurisdictions globally. And when you look at the regulations, it established clear, concise standards across the full system, including, of course, the organizational structure. The minister spoke to the internal control standards, casino credit policies, surveillance, security, gaming equipment, conduct of gaming operations, the prohibition of intoxicated persons, that's very important, from participating in gaming, table games, the duties of holders of specified offices, and so on. So really thorough. It strengthens integrity, it strengthens transparency, it strengthens regulatory oversight, fulsome regulatory oversight, and aligns Jamaica perfectly with international best practice. Now, the integrated resort model, the model that we have here is not what you will see in some other jurisdictions, like in Las Vegas and so on. What we have here is an integrated resort model where these establishments, which are finite, frankly, there's a few of them, or will possibly be a few of them, will be within integrated resort development. So not as standalone casinos. They are ensuring gaming is tied to major tourism investments, hotel, entertainment, ancillary services, and the developments are deliberately limited and tightly regulated with the policy space preserved for Jamaica to tailor and refine the regime as we see fit, and where we need to tailor, we can tailor in the future, and that is important. But what this is doing, really, it's closing a gap within the tourism and the commerce ecosystem. We now can unlock major tourism investments that will support thousands of jobs in construction, and also, of course, permanent jobs. They're going to expand the linkages in the micro, small, and medium-sized enterprises, because let's not fool ourselves. The micro, small, and medium-sized sector supports the tourism sector in a fulsome way. And I think the impact of Hurricane Melissa brought that to bear, and the MPs in Westmoreland, Hanover, and St. James, Trelawney, and St. Ann are fully aware of this. Beyond that, of course, the casino is not just about gaming. It's a place for creatives, for entertainers, for logistics providers, local suppliers, etc. You look at the Hard Rock model, it's not just about gaming, it's about entertainment. So you're going to have some of our best entertainers performing in some of these casinos in the very near future. And of course, it's going to add a new premium offering to Jamaica's tourism and commercial landscape. So again, it's not about gaming alone, it's about expanding Jamaica's economic toolkit and strengthening our value proposition for investors and of course visitors alike. So we'll have new hotel rooms. As you know, Princess, you spoke about housing. Princess built, I believe, 600 apartments for staff. So it is not true that our hotels are not looking about the welfare of our workers. They are. So Princess has established 600 apartments built already. And the MP for Hanover Western is fully aware of that. And beyond that, another development in St. James is establishing about anywhere from 500 to 800 apartments for hotel workers, proper high standard accommodations. So the sector is looking about the interests of the workers. But beyond that, this is timely. It is frankly it's overdue, and I want to give my full support to the Casino Gaming General Regulations 2025 as we seek to continue to grow our country, grow our economy, and look about the welfare of our workers. Thank you.
The member from, opposition leader.
Thank you.
Go ahead. And after that, I think it's a member from Portland, Eastern. Yeah.
Thank you, Madam Speaker. I think the debate here has highlighted two things. One can import a construct which appears to be best practice from a regulatory standpoint and import it into Jamaica and pat yourself on the back that you're doing something wonderful. But when you look at the way this is being introduced into our economy and our society, it's clear that there are glaring omissions which are dangerous and should not have been overlooked. I wish to support what has been said by the member for St. Catherine Northwest. Concerns about consumer protection, the problem of gambling addiction, that the regulations are woefully inadequate in failing to address in any fulsome way, failing to have provisions in them that provide for training, the transfer of skills, for integration of these economic activities into the local economy, for making provision for ensuring that we don't outcompete with other local economic actors in the tourism industry outside of these facilities who will now be facing competition from within. The fact that we are really relying on market conditions to persuade investors to put housing for staff because there's a shortage of staff and they're using housing as a way of attracting staff, which is what had happened in the case of one of them in Western Hanover. Others are having to follow suit, but there's no policy from a regulatory point of view to require this. So, yeah. So we're going down the road again of opening this up essentially so it can, because Jamaicans will be permitted to gamble in here, those who have problems with managing their gambling habits, will providing revenue and profits to operators who will not be Jamaicans. Those monies will flow to the country. And there's nothing in these regulations to prevent that happening. So, to my mind, we have a comprehensive regime coming here, but it's coming probably based on a model which is suitable from whence it came, but it's not suitable for our situation and our risks and our conditions. And we really ought to be using this opportunity to modify that model so as to make sure that this works for Jamaicans, works for our economy, protects our people from the problems that can arise from this activity. Madam Speaker, I also want to use this opportunity to call again for transparency around the fiscal regime that will govern these integrated resorts. When the law was amended a year or so ago, it provides for an ad hoc negotiation of a fiscal package with a particular investor. Something like that has happened in the bauxite and alumina industry over time. We once had a levy regime that applied to all. Subsequent to that, things were modified. Different tax arrangements applied to different producers of alumina and so on. If we're going down that route with these large investments, there should be transparency. There ought to be a requirement for what is ultimately negotiated and implemented as the tax regime for one of these investments to come to the House and be tabled, so we can all see what we're giving away as a cost for attracting that investment, to ensure that it is defensible and appropriate, and so that we can compare it with what happened to others who have made similar investments in the past or in the future. Having it done behind closed doors, negotiated within the government system, and signed off is fine for the investor, but the public has an interest in knowing what we are doing by way of fiscal generosity to attract these investments. And the absence of transparency is a weakness in our regime and should be corrected. So, Madam Speaker, we realize that the government is hanging a lot on this casino this casino attempt to bring investment through this channel. And, you know, it will create some jobs. We hope it will create some local jobs. But the training, the transfer of skills, and all the other things that the member for North West St. Catherine spoke to eloquently, these things need to be put in place to ensure that this works for our people and our country. And it's a disappointment to me that that thinking hasn't informed the development of the regulations here, rather than just adopting what is no doubt a construct developed elsewhere, bringing it here and saying we're doing the gold standard. I don't think that's the gold standard. That's not a modern, progressive, and Jamaican-centered standard, and we should do better. Thank you.
The member from Portland Eastern, after which is the member from St. and South Eastern.
Thank you, Madam Speaker. Now, in relation to the regulations, they are very comprehensive, so I won't repeat what members would have said before. What I wish to speak on, though, is the danger of pretty much allowing regulations from outside jurisdiction, and whether or not we can adopt or monitor in relation to the equipment that has been approved outside of the jurisdiction. So there's a particular, what I'd say, Regulation 55, application for approval of gaming equipment approved by an overseas regulatory authority. The issue with that is, I'm not thinking, having read the entire regulations, that this is something that can be accepted or ought to be accepted in the way that it is placed in the regulations. For instance, the person who is seeking to get the waiver or approval for an item or class of the gaming equipment or gaming equipment seeks a waiver of the technical standards. So the regulation sets up a technical standards, but then is allowing for persons to bring in equipment that the technical standards is either not aware of or can actually speak to its use. Then it creates what is called at 55.8, which is the penalty found in Schedule A, which is just $2 million. So it would then mean that if a casino the casino itself decides to use equipment that prevents or brings unfair advantage or something that we cannot regulate, all they have to do is pay the fines. Yes, pay the sum, and then it's advantageous to them. And then there's nothing in the regulations that speak to how it monitors or how it assesses the equipment from time to time. So it's somewhat problematic. Similarly, there is a fine of $5,000 for the application for waiver for each equipment, and then there is no, in the absence of a guideline as to rejection or approval, it just appears that it is ad hoc, which means they can just accept it and approve it, and if they're satisfied, not even wholesome, but satisfied that that the overseas authorities have checked the equipment, and pretty much there's no protection for the participants if we are to leave it at this. So my contribution is that we should probably, or I give caution in accepting the aspect of this regulation. Thank you.
Member from St. Anne. It's your turn.
Madam Speaker.
Member from St. Anne Southeast. Member from St. Anne. Member from St. Catherine Southwest. Member from St. Catherine Southwest and member from Portland Eastern. You may take your discussion outside. This is not the place for that type of behavior. This is not the place for it. Member from St. Anne Southeast, you may proceed with your contribution.
Thank you, Madam Speaker. Thank you, Minister. The Principal Act is quite clear in its efforts to protect children. And it does provide or prohibits entry by children and the relevant provisions regarding the offense and the penalties. Now, it would seem to me that the regulation should be as forthright in that regard. And in my reading, Minister, I am not seeing those provisions to help to ensure that children are protected and how it's to be done in the regulation. So it's silent as it relates to children and the interpretation of the provisions. And because we want consistency across the board, because with children, we know prevention is much better than cure. And we want to ensure that the industry doesn't put our children at risk. I take the point regarding the integrated approach and what happens, the fact that these casinos will be in hotels. And so the regulation should then speak to how do we ensure that children are not able to move from one section of a property, for example, to another, making sure that floors are properly separated, but also ensuring that there is verification of age of those who are entering to ensure that children are not getting access to casinos. So from my reading, I'm not seeing any of those provisions, and it would be good to hear your thoughts in that regard. The other part of this is related to the reporting. So if it is that children have access to casinos,
what are the reporting obligations, and to whom, how is it done, and what are the implications for licenses, because the regulations are not speaking to it at the moment. So I would love to hear your thoughts on that, Minister. Thank you, Mr. Speaker. Madam Speaker.
Prime Minister.
Thank you, Madam Speaker. I rise because the Leader of the Opposition stated that the fiscal incentives given to projects of this nature, like casinos, large hotels, special economic, commercial activities like this, that there is no transparency involved. Madam Speaker, this may have been the case a decade ago, where it was totally at the discretion of government to grant fiscal incentives to large investors, large economic projects of this nature. And indeed, we would have seen in our past where sometimes the government would have given up significant revenues, given significant tax breaks, and what we would have gotten would not have amounted to the benefit of the revenues that we gave up. Some would say that this may have even been the case with the bauxite industry. But since then, Madam Speaker, we have engaged in very deep institutional reforms of our fiscal laws. Indeed, we have fiscal rules. But more than that, we have put in place several pieces of legislation that govern how governments can provide fiscal incentives. In fact, we have a piece of legislation called the Large-Scale Pioneer Industries Act, which I would like to remind the Leader of the Opposition of, because I'm certain that he would have played a part in debating this bill when it came into effect. And therefore, the Leader of the Opposition is aware that the government is not on a frolic of its own, either by virtue of a minister deciding by himself or collectively by the cabinet to give any special tax break or any special fiscal incentive to any large investor. That is absolutely not the case. Those days are gone. This government is particularly bounded by the law as it relates to how these incentives are given, and they are not done in an opaque fashion. They can be scrutinized, and indeed, they have been scrutinized. They have to be presented to the public. They are not hidden away and secretly done. First, we should also acknowledge, Madam Speaker, that this piece of legislation, like others, including the omnibus legislation regarding certain fiscal incentives to various industries, but this one in particular sets the basis on which fiscal incentives are given industry-wide. So it's not only for a special investor. Once you meet a certain criteria for investment, then this legislation kicks in, and everyone else who meets that criteria gets a similar benefit. Now, of course, some investments may come with certain specific parameters, certain specific requirements, and there is a very limited room as to what the government can do. Indeed, the member may very well know of one particular large investment in Harmony Cove, which took us a very long time to settle on these matters, primarily, Madam Speaker, because we wanted to ensure that there was fiscal coherence, that what one investor got would not put all other investors at a disadvantage. And we have been very scrupulous in this regard. So I want the country to be assured that there is no frolic of giving away the country's tax revenues and other fiscal incentives. There's absolutely no recklessness on our part in that regard.
Leader of the Opposition, please state what is your point of order.
Yes, sir. On a point of order, the Prime Minister, I think, is misleading the House in the sense that my point, which he has not addressed and suggests he is addressing but he's not, is that the regime that is ultimately agreed for that particular investment is not published. We do not know what it is. So the very one to which he referenced, we do not know what the parameters of that fiscal arrangement are for that project. It has been, those parameters have been settled within a system. I'm not saying it's arbitrary. I'm saying there's a system within the government system for doing it. But once it is agreed with them, it ought to come back here and the light of public disclosure ought to apply to it. And we don't know what it is. So that's exactly the point I'm making, Prime Minister.
Madam Speaker, I want to be clear that this legislation, the Large-Scale Pioneer Industries Act, does not give any shield of secrecy to any incentive that is given. The Parliament can always, if they so choose, require it, ask for it. Of course. If it is a tool that is well used in the Parliament for disclosure. So then to come to say you have no means of knowing is misleading the House. So I want again to reestablish the point that there is no arbitrariness in how these fiscal incentives are granted. The discretion of the government is circumscribed in law, and all the decisions are there for the public to see if they so choose to require it. Now, Madam Speaker, it is not always the practice that every incentive scheme is brought to the House. It's, you know, farmers get a particular incentive scheme, hotels get a particular incentive scheme. They're not all brought to the House, but it would be, you know, impractical almost. But if you want to know, it's not hidden, it's not secret, it's not private. If you have a concern, raise a question. Yes, just raise a question. So, Madam Speaker, the second point that I wish to address is the sufficiency of the regulations. I have heard two things said. Both could be true. One point is that the regulations are sufficiently detailed. And the other point is that they don't deal with certain matters enough. For example, the member from Southeast St. Anne raised the issue of how are children treated with in the regulations. His very words, if I were to paraphrase them, would be the regulations are detailed, but I am not seeing how we deal specifically with children. Now, to be clear, Madam Speaker, the regulations that accompany the principal acts are usually meant to give more detailed framework for how specific things are addressed under the law. So it's a more detailed form of the law. But regulations can't go into every single detail of minutia. They are accompanying documents that form frameworks and guidelines that help to effect the law. There is a particular document.
Sit down, man. Okay, man. Sit down, man.
Member from St. Anne.
Yes, so the clarification I see, Madam Speaker, relates to, so Prime Minister, you say the minutiae, but we're talking about the protection of children. In the regulations, we talk about this color, we talk about, I'm seeking clarification on why children would be treated as minutiae when we have the weight of the balls, the color of the balls included here. But the protection of the children is a minutiae.
Prime Minister.
So what is clear here is that, you know, we all want to make a point. And the Principal Act makes it clear that children are prohibited from gambling. It's in the law already, the Principal Act. So I don't know what else should we be regulating when the law itself makes it absolutely clear. Again, the two things can't work together. It can't be either too detailed and then it's not detailed enough. But you're trying to make your point. Anyway, Madam Speaker, the important point that I want to make from this is I listened keenly to the presentation from the member from Northwest St. Catherine and the member from Eastern Portland, and indeed my friend from Southeast St. Anne. And the concerns raised do reflect concerns that the general public who may not have sight of the full legislation, the regulations, and the supporting framework would have. Clearly, you don't want to have children gambling. Clearly, persons who have a problem with gambling, you want to be able to identify them, exclude them, and help them. Clearly, you want to manage how credit is dealt with in the casino. Clearly, you want to ensure that the jobs that are created are jobs where locals have them and benefit. Clearly, you want to ensure that when these new 1,000-room hotels that are being built, that housing accompanies them for the employees. Of course, there are legitimate concerns. but it is not accurate or indeed factual to say that the legislation and the policy of the government does not contemplate or address these things. Now, like every other regulated industry, there is a regulator for casinos. There is the Jamaica Casino Gaming Act, and there is the Casino Gaming Commission. Any casino that will operate in Jamaica will operate under license. And the license will go into the specifics, into the minute details or minutia as to how the casino will actually operate. So yes, we regulate them using the regulations here, but there is another level, which is the license. And there is a framework which guides the actual gaming commission to effect any breach of the provisions in the license. And for example, the framework which will inform the provisions of the license, because, you know, to terminate operations of a casino, it wouldn't only start with a breach of the law or the regulation, but it would start with a breach of the provisions of the license. So, for example, the responsibility of a casino operator. The casino operator has a clear responsibility to minimize gambling-related harm. The Casino Gaming Commission expects the casino operator to be able to demonstrate its commitment to the welfare of its patrons, as stated in its internal controls, which should contemplate at minimum the following: responsible advertising of the casino and of casino gaming in accordance with the minimum internal controls and consistent with the guidelines stipulated below, and with respect to the IRD and the general advertising guidelines appended thereto. So they're going into details now. One that you might be interested in: systems for preventing underage or other vulnerable individuals from participating in any gaming or sports betting at casinos, loitering in the gaming area of a casino, or from gaining access to online, mobile, or in-room gambling opportunities. So they have to put in place mechanisms under their license, which will be scrutinized and policed by the Gaming Commission. So I want to put the House at ease. We did not merely cut and paste best practice legislation from other jurisdictions. It was well thought out, and we need to give. I have confidence in the Gaming Commission and the Ministry of Finance. By the way, this legislation is 10 years or more in the making. So they weren't sitting down, twiddling their thumbs, doing nothing. Yes, it's a long time. And so they have done quite a bit of work to make sure. I'm not saying legislation is perfect, mind you, that's not what I'm saying. But I'm saying that it has sufficiently addressed the concerns, the legitimate concerns about how casinos operate. My final point is that it is not the intention of the government of Jamaica to make Jamaica a casino gambling destination. That's not what we are trying to do here. No. So these are not going to be standalone casinos where the only activity is gambling and you can walk off the street and just go inside here. No, that's not what we're doing. What we're doing is using the concept of the integrated resort, where within that integrated resort you can have different products that attract people. So if casino is not your fun today, you go on the beach. If the beach is not your fun today, then you can go and do some tours somewhere else. And what we are going to be doing is to broaden the offering of our tourism product, to include things like theater and the performing arts, so that we don't just bring in an entertainer to entertain the guests, at night. We need to be putting on local plays that are of the standard of Broadway, that people can come to our country to see performances. That is the kind of investment, and that's where we're thinking, which is why we're going to be building a performing arts institution in St. James, in Montego Bay, to support the development of that. So yes, you will have casino as one, we'll have theater as one. We're looking to, and we have started to work on an oceanarium for Jamaica to be another major attraction. That's the concept. So I want to put Jamaicans at ease that we're not looking to have standalone casinos where you come and gamble and, all the maladies that come with that. That's not what we're trying to do. What we're trying to do is to expand the offering of our tourism product, and therefore casino will be integrated into the tourism product. And it will not be just open for, Jamaicans to walk off the road and into a casino and get caught in anything other than the entertainment value of gaming. And that's the objective of the policy. So, Madam Speaker, and Jamaicans listening, I hope my presentation would have elucidated some of these matters.
Thanks, Prime Minister. Next, the member from Westmoreland Eastern.
Thank you, Madam Speaker. I just wondered for a second. Well, first, I really just want to support the presentation that was made by the member from Northwest St. Catherine. I wondered for a second whether or not persons in the House have anybody in their family or anywhere in their close setting that suffers from addiction. Have you anybody inside of your family or close friend of your family that suffers from addiction? If you have anybody of that nature within your family, then you might be interested in knowing that gambling disorder or pathological compulsive gambling is a recognized mental health condition. Recognized mental health condition that is characterized by uncontrollable, repetitive betting despite severe negative financial, social, and health consequences. It is classified as a behavioral addiction similar to substance-related disorders. So the regulations need to be a little bit more detailed, Pierre, in relation to how you treat with those individuals. Now, for an individual to be allowed to use a credit card to gamble is a recipe for disaster. It should be clear that that is not allowed. I think we all can agree to that. Because debt is a terrible master. If you go to scripture in Proverbs 22 and verse 7, the King James Version, it says that the rich ruleth over the poor and the borrower is servant to the lender. So, it's not a trivial point. It's not a trivial point. It's not a trivial point. No, what I'm saying, it's not a trivial point. If you get caught up in gambling in your 20s, then you have sufficient time to recover. But if you get caught up in gambling and you go into debt in your 40s, in your 50s. It's going to destroy your retirement. We already have a society that doesn't teach financial literacy. And so the majority of persons are already not in a position where they would have made sufficient provision for their retirement. And we therefore have to assist in protecting them against these harms that are out there. The Minister of Health is right there. He can tell you about mental health conditions in the country and the need for greater protection to be provided to those persons. So essentially what I'm asking here, Minister, is that we go a little bit further in providing protection for those persons who have an addiction, the persons who use it as an eye-opener. There's a cage question that we use to check re-addiction. It's an acronym. The C is if you feel like you want to cut down, limit your participation. The A is if you get annoyed when people ask you about it. And the G is if you feel guilty. And the E is if you use it as an eye-opener. As you get up in the morning, it's the first thing that you want to do. Right? It's a quick way of screening persons. Now, clearly, it would also be worthwhile to allow family members to be able to intervene, because the person who is addicted normally does not agree that they have an addiction, you know. Right? And what will invariably happen is that they think that every other hand is going to be the winning hand. Right? That's all right. So
just a point of clarification. I'm using the privilege as was used by the member from St. Anne Southeast. Member, the framework of the whole management of casino gaming in Jamaica does require the casino operator, as I had said in my initial presentation, but to clarify even more, to manage in such a way that the gamer must register and their use of the facility is monitored. And there are minimum standards which set a trigger that would help for quick intervention were there to be any detection of self-abuse or addictive behavior. So there are mechanisms in place. Now, these might be debatable from the point of view of a medical standard versus, you know, any other kinds of standard, but it is not sufficient. It is not fair to say that provisions are not in place. Provisions are in place.
The member from St. Catherine Northwest, and then we go back to the member from, are you finished, member from Westmoreland Eastern? Okay, go ahead, member from St. Catherine Northwest. No, he wants a further clarification. Go ahead. Who are you asking for the clarification? Who are you asking for the clarification, member?
Yes.
Who are you asking for
I'm
the clarification?
offering clarification.
Oh, you are
as has
offering.
been
That's you were not clear on.
Okay, I'm offering clarification.
So member from St. Catherine Northwest intervention is to offer further clarification.
None of us on this side is indicating that there's been no mention of problem gambling. What we are indicating is that the issue is so grave that the simplicity of the mention and treatment, especially to leave it to the observation of a person motivated by profit, is not sufficient. That there are others with better motives that could have been included unless there is a limitation on space. So but we are saying the third party is a family member living with the person, and nothing has been in there. It's a 81 page, I think it was, document. Why is it that these things are impossible to make it 81 and a half pages? I think that it is an unfortunate thing to continue with just the profit seekers to regulate.
Members, I believe, as opposed to turn this into a contentious matter, I think fundamentally we all agree that should somebody have an addiction, that person should be dealt with, and so we can spare themselves and their families a further harm. Because ultimately, if persons are in financial ruin, especially as they get older, some of them will contemplate and carry out suicide. That is a reality, you know. So I am not saying that the regulations are totally inadequate. I don't think anybody is saying that. I'm just simply saying that we should go a little bit further in relation to treating with persons who are addicted, so that we prevent the natural sequelae that will come about if we do not address it. I don't want to come back here to say, I told you so in this matter. I don't want to. So let us deal with the matter from now to prevent the harm in the future to those persons.
Minister Williams.
Yes, Madam Speaker, just to respond to that last point from the last speaker and to close in general, the Casino Gaming Commission that has been in existence now for several years has a very robust program called Responsible Gaming. And I am sure as the industry begins to grow and evolve, you will see these programs evolve as well. I just want to say, Madam Speaker, that in listening to the questions and the comments from the other side, what I note is that they throw up issues that are already dealt with in the regulations. So, for instance, more than one speaker has made a big deal about the casino credit, but if you go to the provision of credit to patrons, Part 4, 28.1, it goes through in great detail that, for example, a casino operator shall not grant credit to an employee holding a senior managerial or executive position at the casino. That's very detailed. A casino operator shall not offer any form of monetary compensation, commission, or reward to any person calculated by reference to the number of credit application or the value of any success. It goes through in great detail as it speaks to casino credit, as it speaks to credit policy, as it speaks to credit agreement. In fact, it is prescriptive. It even talks about the fact that the credit limits should be applicable to different classes of patrons. So there is a lot in the Act and in the regulation to allow us to begin the development of this industry and to know that we have the strictures in place as the industry evolves. I also want to say as well that there was a question earlier on, I think from the member from St. Andrew Southeast, questioning, where do we model this regulation from, right? There are many jurisdictions, but then another member over that side gets up and talk about, oh, you guys are just importing from outside of Jamaica. You guys are confused. Yes. There are In, sure, countries like Singapore, several, yes, in developing the act and the regulations, the technical persons looked at many countries. I'm trying to find the list here. Multiple jurisdictions, and they looked at best practice, and they ensured that they tailor those to the Jamaican context. So yes, they did look at multiple jurisdictions. There was a question to do with, is there any IRD granted? Has there been any IRD granted? And one application was received. There's no gaming license that has been issued yet, and we have one application so far. With regards to the large-scale pioneering industry, yes, a committee to review application is in place. Has the government of Jamaica fulfilled all its requirements to Tavistock? That agreement is still in place, and we are working on it. It was only recently, within the last several months, that the legislation was passed here in Parliament, and I know we have a number of things set out that we have to walk through, that we have to do to complete, but we are working closely with them to ensure that those, or that we fulfill our obligation as well as on their side as well. So, Madam Speaker, I'd like to conclude the debate on the bill and ask for the bill to be read. Hold on. Hold on. Ask for the motion to be approved. Madam Speaker, I now move that the motion, notice of which was given on the 3rd day of February 2026, be approved.
The question is that the motion, notice of which was given earlier, be approved. Those in favor? Aye. Those against? The ayes have it. House Leader?
Yes, Madam Speaker, we'll go back to public business matter that treats with the reports from the...
House Leader, a moment, please. House Leader?
Yes, Madam Speaker, we're almost there. We just have two more matters to treat with. We had concluded the debate on we had suspended the debate on the Income Tax Act just for the Minister of Finance to have some consultation based on the matters that were raised. That has been concluded. So we'll ask the Minister of Finance to now conclude the debate, and we will carry through the stages. Then we will move into our reports from the Ethics Committee.
Minister of Finance.
Madam Speaker, I wish to conclude the debate on the bill and ask for the bill to be read a second time.
The question is that the bill be read a second time. Those in favor? That's the income tax bill. Those against? The ayes have it.
A bill entitled An Act to Amend the Income Tax Act, read a second time.
The House will now resolve itself into a committee of the whole House. The House is now in committee. The House will review the bill clause by clause. Minister of Finance, you will guide.
Madam Speaker, I have two amendments. In clause 2, Madam Speaker, I ask that we delete subclause C and substitute therefore the following. C.
Minister, the clauses that you have amendments for would be clause 2 and which other clause? Don't tell us what the amendment is as yet, Minister.
The memorandum of objects and reasons.
Okay, and the memo. So one amendment really, so one amendment. So Minister, we will start from clause 1 and then we will deal with the amendment to clause 2, in which case, if there are no objections from any member of the committee, we will then take clause 3 to 5 as there are no amendments and the title and enacting clause, or you do. On which one, 4? Okay, and then we take it from there. All right, so members, I put clause 1. Those in favor?
Aye.
Those against? The ayes have it. Minister, clause 2, please repeat the amendment.
Okay, thank you, Madam Chair. For clause 2, I ask that we delete subclause C and substitute therefore the following. C by inserting next after subsection 1C 4B as amended, the following as subsection 1C 4C. At C, with effect from November 1, 2025, any payment for a period specified by notice made by the minister and published in the Gazette not exceeding in the aggregate $200,000 or such other sum as may be prescribed by the minister by order, subject to affirmative resolution in the House of Representatives, which is paid by an employer to an employee for personal recovery and welfare due to loss or damage suffered from the effects of a public disaster declared by proclamation made by the Governor General in respect of an event referred to Section 22C of the Constitution of Jamaica, or a hazard which is the subject of an order under Section 26 of the Disaster Risk Management Act. Thank you, Madam Speaker.
Opposition Leader?
Madam Chairman, it really would have been desirable to see a written version of that amendment so we could look at it. It's quite lengthy, but it doesn't
Opposition Leader, let me share.
I'd be grateful. It doesn't seem to prescribe in it or permit
Taylor, we need a couple copies of the written amendment, please.
It doesn't seem to provide in it for the the ministerial order to prescribe the period during which this payment would have to be made in order to receive the benefit of the exemption. It just says, with effect from November 1 last year, any period, it says for a period, shouldn't that mean within a period? It's within a period, surely. I don't know what payment for a period specified, but it's really... Yeah, I think that the word for should be replaced by the word within, because essentially what this is saying is that the minister would make a notice which would specify what the limit is on the amount of the relief and what period the payment must be made within in order to qualify for the relief. And then you would have a regime that could be updated from time to time by virtue of ministerial orders, which would have to come here for affirmative resolution. So it's a big improvement. I just think the word for in line 2 of the new clause should be the word within. It's not a payment for a period, it's a payment within us. Just as it, in the current bill, it's a period between November 1 and March 31. That's the period that the payment must be made within in order to qualify.
I put clause 2 as amended. Or Minister, do you want to say something first?
Sure, or my technical persons has advised that we leave it as is with the 4.
I put clause 2 as amended. Those in favor? Those against? Ayes have it. I put clause 3. Those in favor? Those against? Ayes have it. Clause 4, the Member Robinson would like to comment.
Minister, I raised this in my comments on the bill. This is clause 4B5. In essence, what this is saying is that somebody who has filed and has an unpaid balance and indicates that they have an unpaid balance is automatically going to be the subject of a notice of assessment. Now, you didn't answer it?
Your answer was insufficient.
Sorry, well, tell me what the answer is, because I didn't hear your answer. So if you can clarify that.
Minister?
It's not, the person will not be assessed. It's more looking at the collection date rather than an assessment date here. It's not about assessment, it's about the collection.
Member Golding?
Yeah, you know, we are trying to encourage people to be tax compliant and to file their returns. Now, if you file a return and at that time you don't pay the entirety of what your self-assessed tax liability is, so there's some balance that isn't settled on that date. What this is saying is if that person the unpaid balance shall be treated as if it had been the subject of a notice of assessment. And a notice of assessment is an act typically by the TAJ assessing a taxpayer, and certain legal consequences flow from a notice of assessment having been served. So I think the member's point is correct. I don't know, the answer is very unclear about it's a form of collection. I don't know what that means. But you're triggering a deemed notice of assessment from the very fact that there was not a complete settlement of the entire tax balance on the date you file the returns.
No. Remember, I'm advised that the section is really creating a deemed collection date, not a deemed assessment.
So House
But
Leader,
she said it was. Well,
you
that's
want to
what
intervene,
want.
House Leader?
No, so I was just saying, to follow up on the Minister of Finance, there's no ambiguity with the provision. The provision is extremely clear, right, and is what it sets out. So, you know, we may not, it's very clear, that's all I'll say.
But but the question, Madam Chair, what is the policy? Why are we saying that if somebody files their returns, and just because there's a portion of that they have not settled on the date they file their returns, maybe they don't have the funding available at that moment, there's a deemed notice of assessment served on them for that sum. Why are we going that draconian way forward with this? Yeah, yeah.
Minister of Finance. Minister of Finance.
Madam Speaker, the further clarification is that when you declare your income, and if you do not pay in full taxes that are due, whatever is remaining, you will be treated as assessed, but you have time, and that's what the amendment here says. You have time, in the case of a person other than a body corporate, specifying as collection date the 15th day of March next, following the end of the year of assessment. So you would have time to pay the balance if you haven't paid in full. Yeah.
And the effect of that is that you're in the system as a delinquent. A notice of assessment will have been deemed to have been served on you, and all the legal regime around tax collection applies to you from that moment. I don't see how that does anything other than disincentivizes people from filing or underreporting their income so that their tax liability matches whatever money they happen to have at the moment when they file. To me, it's a strange policy to be pursuing. I can see from one angle that it's convenient to say, well, you deem this to be a notice of assessment so we can, the full force of what that means. Which is, this whole thing about giving you time is really, to my mind, a euphemism. Having a notice of assessment having been served or deemed to have been served has legal consequences attached to it. And that's what the position you're putting people in. If they file, which if they didn't file, they wouldn't be in that position. So it doesn't make sense.
There's another intervention from the member from St. Catherine South, Northwest.
All right. Yeah, but I am supporting the point made that it serves really as a...
If you don't have a different point that you're making...
Yeah, I have a different point too.
Make the point that...
I will do that. Yeah,
no, man.
Yeah, we're at committee. Right?
No. You don't want to be repeating the point, though. Nothing is wrong in supporting. No. Member.
But no, we have done a long time. Yes, but you know, the intent is clearly not being satisfied by the clause, because a person who is finding financial cash flow difficulties is inspired, is motivated to either file what they have, which is an underfiling, or to delay filing until they have the funding. So what is the intent of this particular thing other than, as indicated, to create a easier method of bullying?
Madam Speaker, I disagree with the view that has been put of it, because clearly we start from a position that taxes are legally due, right? So we start from that position. So the concept of not filing or not doing anything and nothing happen, us in this house cannot put forward that position. So let us start from there. This is a case in which somebody self-assesses, and then on their self-assessment, they pay a portion thereof. What this is saying is that you now have, under this act, the portion that is left, automatically it becomes a notice of assessment. So it codifies what is left that has to be paid. Remember, you have indicated the taxes that you are to pay. If you do not so do, the other avenue is that the tax authorities do an assessment of you. So what this does is that upon what you have indicated, what you have not paid, so you have indicated, but you've only paid a part, you now have until the 15th of March in the following year to pay what you say is left to be paid. No. If you do not so do, then the tax office and the tax authority has the legal authority to move on the notice of assessment. But it actually makes it easier for one to comply and actually gives latitude. And that is because, again, the options that you have proposed are not filing, right? That's the option that you have proposed. And I'm saying, no, but I'm saying in this regime, it codifies what you have said. Remember, the other avenue the tax authority has is that you having self-declared, they can then do their own assessment of you, which may amount to more that would then form the basis of the notice of assessment. The basis of this notice of assessment is what you say to the tax authority that is due to them. It does make it easier. That's my view of it.
Chairman, 2 points. It's not just you get time to pay. Interest accrues at draconian rates for that period. Don't forget that. Secondly, this is an issue, an important issue. There's no hint of it in the Memorandum of Objects and Reasons for this bill. The memorandum, this very short bill has 3 major things it's doing. Only 2 of them are reflected in the Memorandum of Objects and Reasons, and the underlying rationale for this provision is not explained. And I think that's unfortunate. The reality is that this is changing the legal status of a taxpayer in a way that didn't exist before. March 15th is the deadline. We have to file our returns. When we file our returns, we have to pay the tax on the 15th, or interest starts to accrue. What this does is add a further element to it, which is that there's a deemed notice of assessment for any unpaid balance. And that puts you in a completely different regime now, which didn't exist before. And I think it's important, and I think it's in a generally non-compliant environment, or low compliant, better said, a low compliant environment. Anything that may say to somebody who is not in a position to settle their liability, you know, are better off not filing, even though it's my legal obligation to file, is the wrong incentive. Anyway, we've made our points, and I think the minister is not persuaded by them, so be it, ma'am.
Minister, it's for you to close. What say you in respect of this clause?
Madam Speaker, please, I acknowledge what the Leader of the Opposition and the member have said, but I'm going to ask you to put the clause, Madam Speaker.
I put clause 4. Those in favor? Those against? The ayes have it. I put clause 5. Those in favor? Those in favor? Those against? The ayes have it. I put the title and enacting clause. Those in favor? Those against? The ayes have it. Though the memorandum does not form a part of the bill, the amendment, Income Tax Amendment Act, I direct those who have a copy to read, Minister.
There's an amendment
to the memorandum. Yep.
Okay. So, Madam Speaker, for the Memorandum of Objects and Reasons, we want to delete the first paragraph and substitute, therefore, the following. This bill seeks to amend the Income Tax Act and the Income Tax Employment Regulations to facilitate a relief support regime that allows for a non-taxable treatment of disaster relief honorarium made by employers to employees during periods in which a declaration of disaster has been issued pursuant to Section 20 of the Constitution of Jamaica, or on the occurrence of a hazard, which is the subject of an order under Section 26 of the Disaster Risk Management Act. The government recognized the need for the implementation of this policy as another important response to the needs brought on by Hurricane Melissa. Thank you, Madam Speaker.
Madam Chair, if I may just comment on that. It's interesting that in the Memorandum on Objects and Reasons amended paragraph, it uses the word during periods, which is exactly what I said should have been in the amendment in the bill itself, instead of 4 periods. So we now have the bill speaking in language that I think is incorrect and imprecise, which is talks about 4 periods, whereas the new Memorandum on Objects and Reasons uses the correct language, and that doesn't make sense.
Members, just from an abundance of caution, just out of an abundance of caution, members, I am going to put again clauses 1, 3, 4, 5. Those in favor? Those against? The ayes have it. I am sure I'd put clause 2. I want to ensure that what I do is to put clause 2 as amended. Those in favor? Those against? The ayes have it. I'm not sure I'd put it as amended. And in conclusion, I now state the question is that I report the bill as having passed committee stage with one amendment. That's the amendment to clause 2. Those in favor? Aye. Those against? The ayes have it. Marshal? Being back in the House, I do report the bill as having passed committee stage with one amendment. Minister?
Madam Speaker, I now ask that the bill be read a third time.
The question is that the bill be read a third time. Those in favor? Aye. Those against? The ayes have it. Clerk?
A bill entitled An Act to Amend the Income Tax Act read a third time and passed.
House Leader?
Madam Speaker, we will now take the reports from the ethics committees.
Chair of the Ethics Committee, Member Malahoo Ford.
Madam Speaker, the reports of the committee are before the House. I do not know if the reports will be debated. I now move for suspension of the standing orders to enable me to take the motion notice of which I gave earlier.
I put the question. Those in favor? Those are, no.
Madam Speaker.
Those against? Who asked? I'm putting the question, suspending the standing order. Those in favor? Those against? The ayes have it. Apparently, member
stage, we would either embark on a debate on the report or we would adopt the report. I do not know if anyone has any contribution to make.
Madam Speaker.
Here that there is a member who has a contribution to make on the debate. The member from St. Andrew West Rural.
Thank you, Madam Speaker. Madam Speaker, I stand in light of the motion that was raised. On the motion, in light of what was raised regarding member from East Central St. Andrew and Jack then the company, the report tabled concerning the member, Madam Speaker, I'm asking that this be recommitted to the Ethics Committee for further deliberation before the motion is approved. Madam Speaker, a question in the meeting was asked by the chairman of the committee that was not answered regarding Jack then, and from an article that I read, some new information has been received that would require further deliberation on the motion regarding the company in question. Madam Speaker, the Ethics Committee of the Parliament is the responsible body for upholding and monitoring and also enforcing conflicts for legislators to ensure integrity and accountability. And it also investigates allegations of misconduct by members of Parliament for unethical behavior. And with this, Madam Speaker, and in light of what I read in the article regarding Jack then, on the Auditor General's report, I ask that this tabled motion be recommitted to the Ethics Committee for further deliberation.
Opposition Leader of Business.
Madam Speaker, I really am standing in total amazement that a member of the Ethics Committee that would have sat, that would have asked questions, that signs a report recommending the approval. It says here, Madam Speaker, your committee examined the motion for exemption brought on behalf of the member and recommends that exemption be granted. I think probably anybody else could raise an issue, but not that member who is a member of the committee. So I ask, Madam Speaker, that we put this matter to the vote for approval.
Madam Speaker, yes, I am a member of that Ethics Committee.
Member, you can't tell the member to just sit down, please. Member, I just want to caution you that the I want to caution you that the meetings of the Ethics Committee is in camera. So I would not say or give any details of the discussions in the meeting. So you can continue with your intervention without referring to anything that was discussed therein. No, because you raised an issue, she's just responding.
Listen, Madam Speaker.
Let her come in.
Madam Speaker, if I may.
Go ahead, member. Go ahead.
Madam Speaker, the member having spoken on the motion cannot speak again. I sat and listened, and after the member finished her presentation, I spoke. I will not speak again because that is the order of the standing order.
Madam Speaker, the member having spoken has made 2 points. The committee report is before us, and the committee having met and having come to a certain position, that report is before us, right? And we have to proceed based on the report that the committee has made. The member has also raised that she believes that the Ethics Committee...
House Leader, remember there are 3 reports before us.
Yes, I'm speaking specifically. She spoke specifically in relation to 1 report, and that report is in relation to the member from East Central St. Andrew. The member has also raised that based on information that has come to her via the press after the meeting, she believes that ethical issues have been raised that the Ethics Committee should look into. That is a separate matter. So I say that to say 2 things. The exemption motion having come, the member has spoken on the debate of the exemption motion to raise a point which the House will ultimately, and the chair of the Ethics Committee will ultimately have to look into, because again, the standing orders does outline that these are matters for the Ethics Committee, do outline that these are matters. But it is raised on the debate. So outside of that, the debate, the matter having been brought, the committee having met, that doesn't determine the outcome of the matter. So I wanted to separate those 2 matters. You know, 1 matter is before us to proceed, but the member has raised a point on that debate.
So members, just so that everyone is clear, once a report comes, very often they're just accepted en bloc. Even though the member signed the report, the member is saying that having had a meeting, having a report from the committee to the House, we will vote on accepting the report en bloc or rejecting the report en bloc. That is for the House. So that's one. And both leader of government business and opposition quite correct in that regard. So that's the first vote. However, the member is effectively also stating that in her debate on this, she's asking that the member and the company which the member is associated with be referred to the Ethics Committee again based on additional information that has come to her attention. So we will first vote on accepting the report, and then we will, and then it's not before the House, exactly, and then the member would be required to bring a motion to the House referring the member to the Ethics Committee for further deliberation and consideration going forward. And members, this is important because there are implications for how we function in the House if issues of this nature are raised. Right, so members, in respect of adoption of the report from the Ethics Committee, those in favor? Those against? The ayes have it. And member, the clerk will give guidance as it relates to bringing your motion. No, yours, okay too. All three, which is why I reminded.
Madam Speaker, I want to recommit notice of motions given orally.
The question, yes, the question is that we recommit notices of motions given orally. Those in favor? Those against? The ayes have it. House Leader.
Madam Speaker, I beg to move that at the next meeting of the House, I will move the following motion. Be it resolved with reference to the resolution approved by this Honorable House on October 21, 2025, appointing a Public Administration and Appropriations Committee, that the name Damian Crawford be removed from the membership of the committee, and that the name Alfred Dawes be substituted thereof. Madam Speaker, Madam Speaker, I further beg to give notice.
House, it depends on what you want him for. Members, the House is a serious place, so are you asking for a vote, and are you asking for a divide, or are you playing around?
We don't reach, no. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion. Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be it resolved, with reference to the sessional select, joint select, and select committees which are appointed in the current session of Parliament, and where these committees have not completed their deliberations, that in the new session of Parliament, this Honourable House be empowered to enable these committees to proceed with the issues referred to them from the stage reached before prorogation. Be it further resolved that the composition of all these committees remain unchanged except where necessary by further motion taken and approved by this Honorable House. And be it further resolved, with reference to the matters identified below, which are included in the order of business in this session of Parliament, but for which deliberations have not been completed, that in the new session of Parliament, the House be empowered to proceed with them from the stage reached before prorogation. A bill entitled An Act to Establish a Regulatory Framework for Shared Communities to Allow Oversight by the Real Estate Board for the use of and operation of common property to provide for the regulation of the rights and obligations of the proprietors and for connected matters. 2. Private members' motion number 8. Madam Speaker, I further beg to give notice at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion. They're trying to.
Public business. House Leader, public business.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the motion appointing a Public Administration Appropriations Committee, the removal of the name Damian Crawford from the membership of the Public Administration and Appropriations Committee, and that the name Alfred Dawes be substituted thereof, notice of which I gave earlier.
The question is that the standing orders be suspended to enable the minister to take the motion, notice of which he gave earlier. Those in favor? Those against? The ayes have it.
Madam Speaker, I now move that the motion, notice of which I gave earlier, be approved.
The question is that the motion, notice of which was given earlier, be approved. Those in favor? Those against? The ayes have it.
Madam Speaker, I ask for the recommittal of notice of motions given oral. Yeah, I know. I'm going to amend the carry.
Question is that we recommit notices of motion given orally. Those in favor? Those against? The ayes have it. House Leader.
Madam Speaker, I am withdrawing the motion read earlier. I want to thank, for the avoidance of doubt, Leader of the Opposition, I'm going to include. Yeah. So I'll withdraw the motion given earlier, and Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be it resolved with the reference to the sessional select, joint select and select committees which are appointed in the current session of Parliament, and where these committees have not completed their deliberations, that in the new session of Parliament, this Honourable House be empowered to enable these committees to proceed with the issues referred to them from the stage reached before prorogation. Be it further resolved that the composition of all these committees remain unchanged, except where necessary by further motion taken and approved by this Honourable House. And be it further resolved with reference to the matters identified below, which are included in the order of business in this session of Parliament, but for which deliberations have not yet been completed, that in the new session of Parliament, the House be empowered to proceed with them from the stage reached before prorogation. 1, a bill entitled An Act to Establish a Regulatory Framework for Shared Communities to Allow Oversight by the Real Estate Board for the use of and operation of common property to provide for the regulation of the rights and obligations of the proprietors and for concerned matters. 2, private members' motion number 8. 3, the Assets Tax Specified Bodies Amendment Act 2026. 4, the Income Tax Amendment Act 2026, and 5, the Casino Gaming General Regulations 2025. Madam Speaker, I further beg to give notice as at a later stage today I will move for the suspension of the standing orders to enable me to take this motion.
Members, I first put to you the withdrawal of the carryover motion. Those in favor? Aye. Those against? The ayes have it. I now put to you the new motion as read by House Leader. Those in favor? Those against? The ayes have it. House Leader? Public business? We're always in public business in a House Leader.
Speaker, you have to suspend the standing orders to enable me to take the motion first.
Members, the question is that the standing orders be suspended to allow for the taking of the motion, notice of which the minister gave earlier. Those in favor? Aye. Those against? The ayes have it.
Madam Speaker, I now ask that the motion be approved.
The question is that the motion be approved. Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, it is not intended to do any further business today. I remind the members of the House that we start a new parliamentary term on Thursday, a new parliamentary session on Thursday, and as such, we look forward to seeing all the members out early so that we can get going early. And I remind the members of the invitations that they have been issued in relation to the activity in between the sessions. And remind members that after the start of the parliamentary term, that we return at 2 p.m. that day for the tabling of the estimate of expenditures.
House Leader, members, some of the times we need to make sure that we are hearing what is happening so that we are properly informed. We had some challenges at the last ceremonial opening. So in addition to what House Leader said, we are being asked to be guided in the event that we are not here at or before the time we are due to be here. There would be procedures that would limit our access until after the time slot for other activities take place. Like when the Governor General comes and some of us are here after or just at the same time. So we would not be able to proceed until after that segment is completed. I hope everyone understands the point. Members, the question is that we now do adjourn the next meeting of the House being set Thursday at 2 p.m. For a date to be fixed? For a date to be fixed. Those in favor? Aye. Those against? The ayes have it. This Honorable House now stands adjourned.